Hello, I'm Andrea Cooley, one of the owners of Des Moines Mom, and today I'm here with Amy Skogerson and Andrea McGinn from the Law Shop. There are lots of stereotypes about lawyers out there and just as many stereotypes about family law. So today, Amy and Andrea are going to clear up some common misconceptions. I'm going to just kind of read through some different true or false statements, and they're going to answer those. And then if you all have any other questions about family law, please post them in the comments and we will answer them. So the first question or statement would be true or false. Shared care means no child support.
Who's going first?
Go ahead, Amy.
Okay, so before we go too much further, just a little disclaimer that we have to give at the front end here is that the things that we're going to discuss here today are not to be considered or taken as legal advice. This is just general legal information. We would be happy to talk with anybody about their own specific case if they want to meet with us individually. But for today's purposes, just some general information that we hope will be helpful to everybody out there. So true or false, shared care means no child support. That statement is false. And so just real briefly, shared care, what we're talking about there, that term has different meanings in different states. In Iowa, it means about 50-50. Maybe not exactly, but pretty darn close, somewhere in there as far as 50-50 on parenting time. It is commonly thought that, oh, well, if we agree to shared care, that there will be zero child support. That is actually not accurate. We are required to file, both parties are, a child support guideline worksheet based on the Iowa Child Support Guidelines. That worksheet with a shared care arrangement will run, basically what's happening is it's running the guidelines two different ways. It's running it once as if one parent were the primary care parent, had more of the time, and then again as if the other parent had primary care, and then it's offsetting the two. So the higher income earner is typically going to be the person that's paying support, but that support is certainly greatly reduced typically from what we would see as a support amount for a primary care arrangement.
Thank you. All right, true or false, your child can decide where to live before the age of 18.
Yeah, so that one is false. So a child is subject to a custodial order until they are 18. So it is at age 18 that they can actually choose where they're living. Prior to age 18, they can obviously have a preference then, and they're probably going to have an opinion as to where they would like to be. However, they are still subject to that order between mom and dad. So they are still supposed to follow that. Our courts do take into consideration, or can take into consideration then the child's preference, as far when there is a court case going on, as far as where do they want to live, or how often they want to be at mom's versus how often they want to be at dad's, and so on. But there are different factors that weigh into kind of how much weight then the court will give that child's preference. Those being age, maturity level, how they're able to articulate that preference, and things like that. But it is 18 then.
Okay, that is good to know. The first to file has an advantage, true or false?
So we're trending towards the false. That's a false statement as well. It's kind of an old wives' tale that, I got to rush to the courthouse and file before my spouse does because that will somehow give me an advantage. That is not accurate. Whoever files first is simply called the petitioner then throughout the history of that case, and whoever is receiving that documentation that was filed is called the respondent, and will also hold that title for the remainder, even if there are later cases, modifications, and so forth. They will hold those titles forevermore. But beyond that, there is, even including that, there is no advantage to being the first to file the case. And in fact, we usually suggest that people pause and have a discussion perhaps about whether filing right away is the thing to do, because there are sometimes other options. Sometimes people mediate before they file anything and try to get issues resolved in advance. Sometimes there are different ways in which they can retain attorneys to help them get through the process in a little bit simpler way, all those sorts of things. So no reason to go running to the courthouse. Meet with an attorney first, get some good advice.
Great, thank you. All right, true or false, courts favor the mom?
So I think this is a common belief then that I've heard from some people. It is not accurate. Okay. The courts favor what's in the best interest of the child. Okay, that is the overarching factor in any custody proceeding. So what's best for the child? Now, oftentimes it is what is best for the child is going to a lot of times it's going to look like we want the child then to have as much stability as possible, which means we may want then the parenting arrangement to be similar to what it was during the relationship or during the marriage after the separation occurs. So if one of the parents was doing 90% of the day-to-day parenting tasks during the relationship or during the marriage, the court's going to look at that and consider that when determining the post relationship parenting arrangement. And it is kind of presumed then that that congruency between during their parenting during the relationship and parenting after the relationship is usually what's best for the child then, because it creates that kind of stability. That is one factor, again, one of the many factors that the court's going to look at then when looking at and assessing custody. But it does not favor mom versus dad versus mom. That is just simply a myth.
All
There
right.
is, I'm going to tack on that one just a little bit too, because there is some Supreme Court case law in Iowa that talks about how we do need to recognize that parents' behaviors as far as their involvement with the children or how they handle things can and often does change after a divorce, simply because obviously now we have the children shifting back and forth between homes. It can change their duties. But this is a hot button for a lot of people, and we understand absolutely why that is. But I can tell you, I've been practicing 18 years, and it's been a long time since I've been real concerned with whether I had mom or dad or whoever in the scenario. It's really, to me, they're on equal footing, and I've seen that with the courts, and we see a lot more shared care these days than we used to. That's not to say that we don't see primary care arrangement as well, but shared care is definitely more common, and I don't feel in my practice anyway that I'm seeing any kind of preference toward either parent.
Thank you. All right, true or false, we can agree to waive child support?
False. In our list of myths, this one is false, and I think I've actually kind of touched on it earlier, is that aside from no, there's not going to be, it won't be zero necessarily if you have shared care. If you have similar incomes, it could be. But we don't get to waive child support, at least not typically. In order to deviate from what the child support guidelines say that we must do once we plug all the numbers in and it spits out a child support figure, in order to deviate from that, we have to have some kind of good cause, and that has to be significant. It can't be something relatively small or that we're just finessing. It really has to be something real, something meaty, that one of the parents has a significantly higher financial burden, that it would be unjust, unfair, unreasonable really to not follow the guidelines. The guidelines are there to provide consistency for finances being available for the care of the children in the state of Iowa, and so judges like us to stay as close to them as we can.
All right. True or false, my neighbor got a better deal than I did?
Yeah, so we often get people, and I know social media feeds into this a little bit then too, where you'll hear about your friend who had a friend, or your neighbor then who, well, she went to court or he went to court and she got this, and or they can do this, and so why can't we do that, or what have you. So I mean, the classic lawyer answer, right, is it depends. So every single situation is different. Okay, so every single family is different, right? Like your family is not the same as your neighbor's family, so their outcome is going to be different than yours, because you guys have such different facts, such different circumstances that led you to where you are today. So we at the Law Shop, we really focus on getting a fair settlement for your family, right? We do want both parties to come out on the other side then and negotiate with what is in the best interest of your family moving forward, especially if you have children then. Right? You guys are going to have some sort of relationship, even after the divorce or after the separation occurs. So we are really focused on getting that fair settlement while obviously advocating for our clients, but really looking at how can we get a fair deal for you, and also keep in mind the best interests of your family moving forward.
Sure, that definitely makes sense. All right, another question here. We can easily change our custody order later.
Glad I got this one. Um, false. If you haven't noticed, viewers, all of these statements are false. So this one is false too. It is not easy to change a custody order later. In fact, it is incredibly difficult. The standard is always, as Andrea mentioned, for any child custody arrangement is what is going to be in the best interest of that child. However, when you're in an original custody determination, you're both on equal footing. However, when you go into a modification of a custody order that's already in existence, the standard is much higher. You have to prove that there's been a substantial change of circumstances since entry of the prior order. So something new that has occurred that is significant and that has a very clear, demonstrable impact on the welfare of the child or the children. That you also would have to be able to, if you're trying to switch custody or primary care to yourself, or change basically the existing custody arrangement, you have to prove an ability to provide superior care. So the standard is so much higher that we don't even actively take lots and lots of modification cases. Most of our cases are original custody determinations. We try to be very honest with people in their SHOP evaluations if we think that they actually have facts that might substantiate or I guess support a modification action, because if they don't have it, we don't want to waste their time and money. And so we don't take all of them that come in the door for that reason.
All right. Okay, this is a good one, or one that I think is interesting. True or false, most divorces go to court?
That one is definitely false. Majority of the time, and when I say majority, I mean the vast majority of the time, you are not going to step foot into a courtroom during your divorce case for anything, let alone going to a final trial, okay? I think the stats then, don't quote me on this, anyone, but the stats are probably upwards of 90% of our divorce cases are settled outside of court. It may even be higher than that. It is very common then that cases are being settled at or before or at a final mediation. So the court requires you to attempt to settle your case at a mediation before you're even allowed to step foot into a courtroom. Now, especially during COVID, you're probably not going to step foot into a courtroom. A lot of stuff is still happening virtually. So that's another factor to consider right now. But no, most divorces do not go to court, especially everything that we do at the Law Shop too is really, like I said before, geared towards getting you that fair settlement. Everything from the language that we use in our pleadings and the documents that we file with the court to how we communicate with the other party and their attorney if they have one, and how we negotiate, all the above, then really geared towards getting that settlement, and most of them end in a fair settlement. So
Okay, we've got two more here. Another good one here. My friends who got divorced used the same lawyer.
Okay, so on our track of false statements, that's one of them. It's very understandable why people believe that their friends use the same lawyer, or even that they believe they use the same lawyer in a prior divorce that they may have had. But Iowa's attorney ethics rules actually specifically prohibit one lawyer representing both parties in a dissolution of marriage case. So the reason that it's a common misconception is that it is really common for there to only be one lawyer on the scene, but that lawyer is actually representing one party and then purely communicating information, not advice and not confidential communications, but just regular old legal information to the person who is unrepresented. represented. So we see this a ton, where there's one lawyer that's kind of doing all the legwork, if you will, but representing only one party. So how we handle that in our office is that if we are that attorney who's involved, then we're going to be working with our own client, providing necessary information that we're allowed to provide to the other party, but then also suggesting that that other party, that other person, visit with an unbundled legal services attorney prior to signing the final agreement to make sure that they get their questions answered and that they have a set of legal eyes that can give them advice if they need it on that document before they sign it. So it's a nice money saver to be able to do it that way if parties can agree on most things, and we see quite a bit of that in our office. But it would be unethical for really any lawyer, at least in the state of Iowa, to represent both parties and have their name on the court file for both parties, and to have the representation involves confidential communications, legal advice, things that we can't do with somebody who is not our client. So.
That makes sense. All right, last question. I think this will be a good one. We touched on it a little bit in a previous interview, but I can't afford a lawyer.
Yeah, so I'll try and make this one as short and sweet as possible. Give us a call. There are other options besides a thousands of dollar retainer. Okay, so at the Law Shop, we offer many different levels of representation to get you through your legal proceeding. Everything, we kind of explain it on a spectrum then, I think, like we've talked about before. So if you want to handle some of it yourself, you can bring us in and kind of work with you on the background on coaching you through it, on doing it yourself. We can come in for bits and pieces of it. We have multiple flat fee options as well. And there's many more and more law offices out there that are offering that as an option as well. So look into it, call around. The Law Shop will offer you that option, and we can provide names for the other party to look into that as well if they want to. So you can afford a lawyer. There are other options out there outside of that multi-$1,000 retainer.
Great. Well, thank you both so much. Hopefully this answered a lot of questions for people about family law and cleared up some common myths and misconceptions that people have. And if you have any further questions or are looking for advice in a family law case, where you can find Amy and Andrea with the Law Shop. Thank you both.
Thank you.